I am Siaman Rajput, and it's my privilege to welcome you all as a moderator of this session. This is important webinar organized jointly by the Committee on Corporate Laws, Economic Advisory, and NPO Cooperative of ICAI on the occasion of International Literacy Day. Today's webinar will be on will drafting, and state planning. This has been thoughtfully curated to bring professional insight and practical guidance for chartered accountants as well as shareholders at large. Before we begin, let me allow you to tell you about this committee of ICI. This committee plays an important role in enabling chartered accountants to shape strategies and policies that unlock economic, financial, and social value while combining analytical fortnight with commercial acumen. Its core functions include policy analysis and knowledgeable discussions, offering inputs to regulators on crucial legislative and economic matters, developing technical guidance and background material, and creating awareness on professional opportunities in commercial law, economic advisory, and NPO cooperatives. Through incentives, through initiatives like today's session, the committee continues to build capacity and awareness in areas of professional importance. Today, we are honored to have CA Dr. Dilip V. Sadbhai sir, the eminent speaker for today's session. Sir is a senior partner at DV Sadbhai and Company, which is located in Pune and has held several prestigious positions, including chairman, vice chairman, secretary, and treasurer of Pune branch of WIRC of ICAI. He has contributed immensely to the profession, serving as a co-opted member of various central and regional committees of ICAI. His academic brilliance includes a master's in law, he is a gold medalist in law, and PhD in law. Sir has authored ICAI handbooks on will drafting and nomination nomination related publications and contributed to some publications of GST and investor awareness as well. His expertise includes direct and indirect taxation, forensic audit, risk management, government accounting, and wealth planning. Beyond the profession, he has been actively associated with several NGOs working on causes ranging from health to education and social upliftment. His dedication to both profession and society makes him an amazing figure. We welcome you, sir.
Thank you. Good afternoon. Aman, you have done a good job by introducing in a very brief way and in a brief time. Time is very essence and time is very important for all of us. So thank you, Aman, for introducing me.
Thank you.
So to begin with now, let us start with the session on two parts. Basically on the general matters, we are going to have a legal literacy, which will be covering up the wills as well as the state planning and some other laws, as the committee has already pointed out. So the lecture will be divided into two parts now. The first part will be literacy part, and the second part is the legal literacy part. So there is a demarcation in between literacy and legal literacy. So what is the basic difference in between these two? What expected are what the stakeholders are expected to know about the legal literacy and normal literacy, how that will help, what are the impacts of that, and what are the case studies that we need to have and discuss in order to understand the legal literacy in a better way, so that we also would be literate in the times to come. So literacy is very, very important, and that's the reason why we need to concentrate on those particular points. One needs to note down that by reading a book or understanding certain matters from others doesn't make you literate. It only enhances some sort of a knowledge. But can this be considered as literacy? Technically speaking, answer is no. And legal literacy is beyond that. Legal literacy says that you need to understand everything in the way in which the legislature had jotted down the points, and you have understood those particular points in the similar sense, the sense in which the legislature has ultimately jotted down these points. But whenever there is a confusion that you might be interpreting in one way, the other might be interpreting in the other way. So there is a confusion of interpretation. So in that case, the legal literacy will be enhanced with the help of the opinions which have been given by, or judgments which have been given by, the various courts like High Court, Supreme Court, District Court, Judicial Magistrate, some or the other courts in itself. So the decision which have been given having a binding force in the eyes of law, those will be the major issues those we will have to discuss in these particular scenarios. And that is the area where we need to concentrate upon so far as the legal literacy part is being concerned. So let us talk in terms of the only literacy, not the legal literacy. Literacy generally refers to the ability to read, write, comprehend written text. Now I will give you an instance and just you tell me that whether you have understood the literacy part of that or not. In Ayodhya, Sita, Ram and Lakshman attended the marriage. I repeat again, Sita, Ram, Lakshman attended the marriage. How many persons were there? If the question is there, you simply would say, how many are there? Sita will be one, Ram will be other, Lakshman will be the third. So 3 persons are being there. But if you see the text of that particular wordings in itself, there is no comma after Sita. There is a comma after Ram, but there is no full stop after Lakshmana is concerned. So in that particular case, technically you will not call those particular persons the 3 persons, but those persons will be 2 persons because there is no comma after Sita. So literation, the literacy part of that is you have to give lot of importance to the word where the comma is being there or where the full stop is being there. And that literacy part is not there in common literacy, which is there in case of legal literacy is being concerned. So keep this particular point in mind that comma plays an important role. So if a strict interpretation or a liberal interpretation is to be carried out, liberal means as what normally you feel. So normally as what I just made it out, liberal interpretation, Sita, common, Ram, another person, Lakshman will be the other person. So total 3 are there. But if you go by legal meaning of that, comma will play a very important role. And after Sita, since there is no comma, Sitaram will be considered as a male person and Lakshmana also will be called as one person. So in all, only 2 persons will be there and not 3 persons as normally envisaged in case of the literacy factor is being concerned. So this is the major difference in between the word literacy and the legal literacy part is being concerned. So only reading, writing and comprehending what you normally feel or what the logical conclusion that what you are ultimately arriving at is not of much importance. Whether the legal binding of that particular sort is being there or not, that you will have to look into, and that is what the major thing is required to be covered. It is the foundational skill that enables individuals to communicate, learn and function effectively in the society. So not necessarily that you need to have that much knowledge, only it should be capable of being percolated downwards to the society as well. Let us take one example. A person who can read a newspaper, write a letter, or understand instructions on a medical bottle demonstrate literacy. For instance, a student reading a novel or an employee filing out a form of at work is using his general literacy skills. So reading or writing is a normal skill which is there with them that only will bring them to literacy level. They will not go to the legal level so far as the technicalities are concerned. So now let us move on to the legal literacy now. Legal literacy is the ability to understand, interpret and apply legal information in everyday life. So whatever is being paid, that should be made uniformly applicable to all the citizens in the country in itself. That should be the way that you have to understand, interpret, and apply the legal information. It involves familiarity with legal jargon, understanding one's rights and duties, and recognizing potential legal issues. So all these three are the basic ingredients of this particular legal literacy. So legal literacy empowers people to navigate and engage with a law effectively. In short, it is what legislator wished, and later on about confusion, what courts have said is the final dictum so far as the legal literacy, the contention of the general remark or the conclusion part that we need to learn about. Legal literacy is also the ability of individuals to understand the legal concepts, processes, rights, and to use this knowledge is the major factor so that they can take appropriate action and advocate for themselves. So note one point that legal literacy of lawyer we are not talking about. Legal literacy of other professionals we are not talking about. We are talking about only in case of chartered accountant and general, whether how they can have a legal literacy, whether they have having a literacy or whether they need to have a legal literacy. In the fact of that, we need to concentrate on these particular matters. So this is how you have to look at the point so far as the legal literacy part is being concerned. I got another 15, 18 legal literacy case studies in itself, which we will be having a detailed analysis of that, and you will come to know that these are how these are comparatively more important so far as the common man is being concerned. So I will just move on to the important case law first, and then we can come back to the topic in itself once again. Now, the first point, it's a normal case that you need to understand. There was a girl named Sunita. He got married to a military soldier in Bihar. And when they married with the word named Harish in itself, he was a young soldier. Later on, he was posted to Kashmir Front. So see the situation, a lady is there, she got married with Harish, and the young soldier later on, soon after the marriage in itself, was posted to Kashmir Front. Days after their wedding, he went missing in action. Days after their wedding, he went missing in action. For years, Meera waited, clinging to hope, praying for the news that her husband will come back. After a decade of silence, the army declared him missing. After 5 years were passed, and Meera, now in her late 30s, got remarried on the advice of some person saying that anybody who has not been found out for a minimum period of 7 years of time is presumed to be dead. And if the person is dead, the question of persistence, consistence of knowledge, or the marriage in itself, consumption of marriage doesn't arise. But see the situation as what we normally see in our day-to-day life and in the Hindu movies also. After nearly 22 years of lapse, Harish re-emerged on the screen, and only to notice that his wife was remarried. He got furious, agitated, and filed a case against the wife under Hindu Marriage Act, accusing her of bigamy. So you know that under Hindu law, Hindu Marriage Act 1955, principle of monogamy is being followed, and the principle of polygamous marriage and polyandrous marriages are being removed so far as the marriages factor is concerned. Polygamous marriage, more than one wife. Polyandrous marriages, more than one husband. So accordingly, this is required to be seen so far as the technicalities are concerned. When the matter went into the courts in itself, the court observed that you have not acted judiciously and there is a lapse of certain points on your part and your lawyer in itself as well. So what was being pointed out is very, very important. It was pointed out by the courts in itself that there is a ground under section 13 of the Hindu Marriage Act under the ground divorce, where it has been pointed out that if you are married and the other spouse is not being heard of for a minimum period of 7 years of time, then in that case, the person can be presumed to be dead. And that can be one of the grounds for ultimate getting a divorce. The lady should have had obtained a divorce first and then later on she should have had married. So as a result of which now she has been found to be guilty under the provisions of law, but only after admonition she was being freed by the judges in itself. This is the legal literacy, not just knowing the law, but knowing how to apply it. Mira's tragedy wasn't just emotional, it was legal. Had she known the law, she could have had protected herself from this heartbreak. So, one more point I have added to this particular legal literacy, and that part is very important. Not only knowing law is enough, not knowing only law is enough, but how to apply that is also equally important, which has been decided in this particular case. So this is how you have to look at the point so far as the generality of the topics are being concerned. And once you look at that particular point, you will find that everything is going well so far as the technicalities are being concerned. Similarly, you can find out under General Clauses Act, similar versions are being there, which ultimately talk about the full stops, commas, and some other words. Now, whenever you are interpreting certain words, more emphasis is required to be given on the word may or on the word shall. Now, when the word may is being used, in that particular case, it becomes an optional matter so far as the things are being concerned. But once the word shall is being there, then in that case, there is no option for you to get the things done so far as the normal matters are being concerned. So when you enter a room, you always say, may I come in, sir? Which means that there is an option to the other person sitting in the room in itself, either to allow you or not to allow you. But when the word shall is being there, shall I come inside you? Then there is a obligation on the part of the person sitting inside that he has to consider that particular matter. So this is how the things are being there. The word may and the word shall is required to be used, and that word may or shall will improve the quality of the legal literacy in the times to come in itself. So this is very important factor of the word may is being there. And once you use that particular word may or shall, as the case may be, it will improve your legal literacy so far as the technicalities are concerned. Similarly, some other views are also there. For example, some issues are there which are jotted down in the text in itself in plural number, and some are being specified in singular number. Sometimes the word used is he. Whether he includes she or whether she includes he will be the issue that we will have to look into. Normally speaking, in male-dominated community where we are now, almost all laws recognize this particular gender position as male position. And as a result of it, you will find that all these aspects are being, the words which have been used is he everywhere. So does that mean that only he means only male is being addressed under the law? Or whether the word he will include she? Technically speaking, she will include he, because last two alphabets are SHE. HE is the last two alphabets in itself. So she will include the word he, but he cannot include the word she. But law presumes. That presumption of law is very important. That presumption says she will include he as the case may be, or he will include she as the case. And that is how the interpretation is required to be carried out so far as the technicalities are concerned, which will improve the legal literacy of a person so far as the technicalities are concerned. Similarly, singular is being used for the words in itself instead of plural, or plural are being used in the case of singular. Illustration can be, normally we see in our company law matter, chartered accountants are well aware of it, that in case there is no quorum within half an hour from the presented time of the meeting in itself, meeting will adjourn for a period of another half an hour or next week at the same time or same issue, etc. But in that case, there is one more line. In that meeting also, if there is no quorum, members present in the meeting will form a quorum. So the words used in this particular context is members. It is in plural number. And now we have to find out an interpretation here. What will be the interpretation if only one person is present? In that particular case, only one member is present over there. Will that constitute a quorum in itself? So here is the question of interpretation that we will have to make into and we will have to look into. Supreme Court has already laid down that only one person will constitute a quorum, but which I personally do not agree with that, because the word members is a plural one. Though General Clauses Act 1827 talks about that singular will include, plural will include. But what is the meaning of the word meeting? The word meeting means meeting of at least two persons. And unless there is a meeting of two more persons, how there can be a meeting in itself? How one person can meet himself? So that is the issue, and that is the reason why I personally had pointed out that this is not the correct decision according to me. Maybe correct so far as the legal decisions are concerned, maybe followed throughout the country in itself. But technically speaking, when you call a meeting, meeting means one cannot speak to himself or the walls just in front of them. You have to have minimum two persons in itself, then only that meeting can be there. Otherwise, it has got no meaning so far as the technicalities are concerned. So this is how the interpretation gets improved. That is the legal literacy I'm just talking about. So legal literacy gets improved or a literacy part is being concerned. I will give you one more illustration because this is a case study based topic. By giving only simple lectures one after the other in itself, a classroom session, that is not going to work out so far as the matter is being concerned. So we have to concentrate on these matters with the help of some illustration, which perhaps could be remembered by all the persons together throughout their period of say 2 hours is being concerned. Let us take one more illustration and try to find out what more thing that we need to learn so far as the legal literacy part is being concerned. Now, you perhaps would be remembering in the olden times that there was a clause that the return of income can be filed within a period of 1 month from the completion of the accounting year or within a period of last day due date of the accounting year. That was the period that was being specified. And penalty will be levied for a period of 1 month and thereafter. Now, if the return was delayed by 29 or 30 days and a month was not being completed, in those particular days, the experts interpreted that you cannot levy penalty because month is not being over. 29 days are only over now. So even though the last date was being 31st of July, the return used to carry out till 29th of next month in itself without attracting any penalty in itself. These are the words of wisdom that you need to inculcate, which is the legal way to understand the legal literacy part is being concerned. And that is the area where we need to concentrate on to find out that how the legal importance is required to be noted down so far as the matter of law is being concerned. So that is how we have to look at it so far as the technicalities are concerned and so far as the matter of general matters are being concerned. Take one more case on Hindu law, perhaps I'm more familiar with because of the HUFs and other things are concerned. Now under Hindu Marriage Act, there is a provision and almost all books including Mullah of Hindu law had jotted down certain principles of restitution of conjugal rights. When there is a difference in between husband and wife, wife runs away or husband runs away, they don't meet each other, and ultimately the very purpose for which marriage was being ultimately solemnized ultimately doesn't get into fruition in itself. So in that particular case, there is a provision in the Hindu law which says that if one of the parties runs away from the scene in itself and the other party is prepared to consume the marriage, then the concerned party can go to the courts and ask the other party to come to marriage, to come to house in itself and enjoy the matrimonial life. If she doesn't agree or he doesn't agree, then in that case, court orders, yes, what you are saying is precise, and ultimately either husband or wife must come to house in itself. That is called as restitution of conjugal rights. Conjugal means matrimonial, restitution of matrimonial rights. Now here normally 95% of the people feel that ladies are running away from the matrimonial life and they need to be brought back. And that is the reason why almost all Hindu law books have specified an illustration. It is just like a case of a cow running away from her shed and now bringing back that cow to again shed in itself. So this is the illustration that has been given. It's a wrong one, because it is not only the cow that needs to be brought back, but it is also the bullock also is required to be brought back, because sometimes it may happen that the man might run away from the scene, and in that case you need to bring back that bullock again back to the shed in itself. So the legal literacy part is here. We 95% people claim it is only in case of the women restitution of conjugal right can be enforced. That is not the case. Here you have to make it out even in the general case also. Even if man has also run away from the screen in itself, you have to bring back that particular man in the form of a bullock back to the shade in itself. This will improve the quality of your answer with the increase in knowledge so far as the legal literacy part is being concerned. And that is very important so far as the technicalities are being concerned. There are other issues also in the Hindu Marriage Act as well, and that also you can make it out over a period of time is being concerned. Now there are certain issues pertaining to the properties. Now what are the proper issues pertaining to the properties? Because you become old, you become comparatively not capable of executing any document. So in that case, you need to have a power of attorney. Now, power of attorney, everybody knows that it's a delegation of authority. It is delegation of powers. Whatever power that you have got, you can give those powers to them. So it is based on the same principle of nemo dat quod non habet, which means that no one can pass a better title to the goods than what he himself has. So I cannot sell Taj Mahal today. I cannot sell Lal Killa today. I cannot sell my Shaniwar Wada today. Why? I am not the owner of that. Unless I am the owner of that, property cannot be sold out. So that is what that nemo dat quod non habet principle is required to be jotted down. And now in the light of that now, whether a power of attorney can be divided into two parts, answer is yes. One is called as a general power of attorney and the second is called as a special power of attorney. When a power of attorney has been given for almost all matters, do everything from Tom, Dick, Harry to from pin to piano activities in itself, it's a general power of attorney. But if you are saying no, this is only for withdrawing money from the bank, it's a special power of attorney. Nothing wrong, it's a normal literacy that everybody will be having. Now the problem comes when the property is in the form of an immobile property. So if it is an immobile property, in that particular case, the law specifically says that whenever a delegation of power pertaining to the immobile property is required to be given to any other Tom, Dick and Harry, the document is required to be registered. Registration is very important, without which that power of attorney will have no value. Registration with the sub-registrar of that particular area, not the notary public or notary which we normally see. So in that particular context now, I have to invite your attention on one ticklish issue which ultimately makes it very, very you may call it as a difficult for to answer in itself, is about the non-resident person. Now, non-resident Indian or Indian resident, both are being Indian citizens, normally in 99% cases. But if they have changed their citizenship, that's a different story. I am talking about NRI, non-resident Indian. In that particular case, if he holds certain property inside India, if he holds certain property inside India and he wants to dispose of that property to getting that money encashed and taking that money to US. Now, what is the solution? Is he expected to come back to India? Or is there any way? And that way is not known to hundreds of people in this particular matter. That legal literacy is very important so far as the technicalities are concerned. That non-resident person can prepare a stamp paper and just go to the Consulate General's office, just sign in front of them and get the property transferred in itself. It is so simple, but since it is not being known to common person, they become very, very worried about that as to how this can be done, how much airfare will have to be paid, how much money will be wasted, and other things are being concerned. That is not the issue. Only thing that what you need to look into here would be that how these things can be carried out so far as the technicalities are being concerned. And this is what the precise issue that I am just bringing it to your notice, which improves and qualitatively enhances the legal literacy part so far as the topic and the technicalities are concerned. So this is what the non-resident person is talking about. Now, you are aware, and this under the same act now, there are certain provisions that whether registration is mandatory. Yes. No, normally everybody does not know that registration is mandatory in case of immobile property. May not be registered in the case of movable properties are concerned. Now, if the property is being sold out, then the people are unaware of the fact that within 4 months of time, this property can be registered. So, if you are going backdated, you are going in that particular area, then you can have a 4 months backdated agreement and it can be executed. You can have agreement as of today and get it registered with the next 4 months of time. And that gives the leverage to you to adjust the requirements of the various customers that would be approaching you in itself. So that is how the things are required to be looked into so far as the technicalities are being concerned. So this is the technical issue that ultimately will make you much more proud, and accordingly the things are required to be carried out so far as the matter of law is being concerned. So law is very, very important. You need to understand law in its true sense is the presumption of law. That is very important feature which you need to make it up. Take a common case now. Official Gazettes Act 1965. Any matter that has been published in the official gazette, whether you have read it or not, law presumes that you have read it. Not only you have read it, but you have understood it. Not only you understood it, but you have understood it in the very sense in which ultimately it was being published. For example, if a person is being there having a surname Kavle, not a good name normally in Maharashtra is being called about, because Kavle is the name of crow. So Kavle was the name of a particular person and everybody used to call him Kavle, Kavle, Kavle. He was getting agitated, as a result of which he thought that I should change my name in itself. So accordingly, he applied, got his name modified, and some options were being there. He did not put on any option. And as a result of which now, the name that was being given to him was not only Kavle, but extended name as Dom Kavle was being concerned. So Kavle became Dom Kavle and the matter was being published in the official gazette. None of them read it out. Nobody, even he himself, read it out. But Kavle became Dom Kavle, the date on which this official gazette ultimately was being published in itself. How many of us normally knows that the official gazette is required to be looked into, or official gazette is required to be pursued upon, and once it is perused in itself, ultimately the things are required to be looked into. This is how the things are being there, which we need to look into, which we need to address so far as the matter of law is being concerned. This is the technical issue where I am highlighting or inviting your attention on. So these technical issues, you might be knowing the entire law, but if you are not knowing the intricacies of the law in itself, then your knowledge will be only literacy part. It will not become the legal literacy part. That is what I'm just bringing it to your notice. We chartered accountants are financial experts. We are financially literate. But do we are legally expert or legally literate so far as the things are concerned? We can give our illustration saying that we are the financial consultants and we are financial experts and literate persons in itself. I remember a small story that I will just share with you, which are the financial matter which we need to consider, which is equal to that of legal literacy. And as long as we concentrate on these matters, similar matters, we need to consider in legal literacy as well. A gentleman having 500 crores of rupees as wealth was having two sons. One was a doctor, 95%, 97%, 98% in all examinations. And the other was a chartered accountant, comparatively wiser in finance, knowing that what is required to be done and how it is required to be done. But his father, both of the sons and daughters, son and one and son two, CA and doctor, their father was not satisfied that whether they will be able to shoulder the entire property worth 500 crores or not in itself. So he wanted to test. He said they called a doctor and chartered accountant, say I have got becoming old now. I'm going to die sooner or later. And as a result of which you will have to manage the entire property. But I will decide about that later. But let me do one more thing, because every day I go to temple in itself, Hanumana temple in itself, and I give 1 rupee coin to that temple in itself. So, Dr. Son, you take this 100 rupees, go to my friend money changer, ask him to give 100 coins and pay him commission of 10%. He charges commission of 10%. Then the doctor's son took those 100 rupees, went to money changer. He said that my father has asked me to get a change. I have got 100 rupees with me. Please provide me 100 change. Then he said, okay, I will give you change, but my commission is 10%. So I will give you 100 minus 10, 90 rupees. So the doctor's son calculated similarly. Okay, no problem. 90 rupees is okay for me. So accordingly, he took 90 rupees. Then in the afternoon, a chartered accountant was being asked, take this 100 rupees. I want coins also. I need more money. So go to the money changer. He will offer you 10% commission and ultimately bring back the money in itself. So chartered accountant, while going over there, thought over the matter, which is the literacy and legal literacy part, which I'm just making up. He thought that why my father has not given 200 rupees to doctor and 100 rupees to him and 100 rupees to me. Is he testing us? Is he examining us? Is he finding out that whether we are capable of doing or not? So while going over there, he thought over the matter, knowing the fact that doctor's son or doctor brother had brought 90 rupees with him in itself. So he said that no, we need to at least have minimum 90 rupees. Can we get more money out of 100 is the major point that he wanted to make it out. So while going over there, he found a calculation and found literate part of that, which is the financial legal literacy I'm talking about. While going over there, by arithmetical calculation, he asked the concerned money changer, sir, I need some coins. He said, okay, no problem. My commission is 10%. Then he said, I want 90 rupees commission, 90 rupees coins in itself. Then he said, okay, no problem. 90 plus 10% commission, 9 rupees, 90 plus 9, 99 rupees. He gave 100 rupees currency note to him and he got 91 rupees with him in itself. So Dr. Son also applied the same technique. Chartered accountant also applied the same technique. But Doctor's son, 95%, 98% got only 90 rupees with him, but the chartered accountant got 91 rupees with him. It was a case of 100 rupees. Had it been a case of 1 lakh, it would have been a difference of 1,000. Had it been a case of 1 crore, it would have been a difference of 1 lakh. Had it been a case of 100 crore, it would have been a case of 1 crore, and so on. So that is what the legal aspect which we need to make it out, and the calculations are required to be made it out. You have to think something differently to make it out, that what perhaps could be the possible solution in a legal matter in itself, that ultimately will solve the matter so far as the technicalities are concerned. Father was satisfied with the chartered accountant, but he said, no, I'm not much happy. I would like to have one more technical thing that I will have to look into, then I can think about it. Then he told both the sons, Doctor son, your auntie is coming, that is his sister is coming, and you have to go to the railway station and pick her up, bring back home. So accordingly, one sister was to come at 2 o'clock, the other sister was to come at 4 o'clock. So the 2 o'clock sister will be received by doctor, 4 o'clock sister will be received by chartered accountant. So the concerned boy, doctor, went to the platform, saw that platform ticket is mandatory, no choice, 50 rupees is required to be paid. So accordingly, he went to the cabin, found out that ultimately window was there. He paid 50 rupees, took out that 50 rupees, went inside. The train came exactly at 2 o'clock. The sister came, and bringing back that sister home, ultimately the father asked, so you have picked up my sister correctly? How much amount you have spent, how much you have spent on rickshaw, etc., etc. Everything was being jotted down, but he noticed that he paid for the platform ticket. Later on at 4 o'clock, chartered accountant went over there. Then he went over there, he found out that the platform ticket was worth rupees 50. Then he looked at the entire ticket collection which was being just jotted down, fare which was being jotted down. It is, if it was in Mumbai, then the ticket for Bhaikhala, then Bhaikara for Dadar, everything was jotted down, as like in Pune also. Pune main station, Shivaji Nagar, Karki, then Pimpri, etc. And he found out that the ticket for Shivaji Nagar, one station next to Pune railway station, was at rupees 20. Then he said that, can I not have that 20 rupees ticket and go on the platform? He said, okay, no problem, you can go. So instead of paying 50 rupees for platform, he bought a ticket of Shivaji Nagar and went on the platform in itself. Exactly at 4 o'clock, the train came. And while coming back, the sister of the father, that is auntie in itself, came over there along with the son number 2, chartered accountant, and came out of the platform in itself. While coming, the chartered accountant again saw, if the ticket is cancelled within a period of 3 hours, 50% only will be allowed. Full repayment is not possible. He said that already 3 hours are not over. So he went back again. I don't want to go to Shivaji Nagar. Give me my refund. So accordingly, 50% of 20 rupees was being given back, and 10 rupees was being the only charge that what he paid. So see the situation here. Chartered accountant paid 50 rupees. Chartered accountant, doctor also paid 50 rupees, but chartered accountant ultimately, finally bringing back home the sister of his father in itself, only spent 10 rupees in itself. So more literacy is being there about financial matter so far as the matter is concerned. And that is the legality aspect that you have to move it up so far as the matter of law is being concerned. This is also a law that you have to interpret the financial wizards in such a way that ultimately you improve over a period of time is concerned. And that is how the things which are required to be looked into so far as the technicalities are concerned. And once you understand those particular legal matters in itself, then nothing is difficult so far as the matter of law is being concerned. Now, you might be aware that there are always the disputes in the family, for which now we are going to talk about the will part in itself later on, after another 15 minutes of time. So in that particular context, there are always tussles in between the brothers and sisters, stepbrothers, stepsisters, and many other similar members in the family. Now, if there is no dispute among the natural brothers and sisters, which means that they are being born from the same husband and wife. In that particular case, should there be any dispute? Is there any solution for that? Whether it has been specified or it is the interpretation of law that you need to make it up. Now, in one family, there were 4 sons and daughters. There was a piece of land, and everybody was worried about that which part of that particular property will be given to whom. Everybody was curious. When one person used to say, I want A plot, then in that case, the B was saying, no, no, I want that. C was saying, I want that. So everybody, they were quarreling with each other in itself. Now the question came, the interpretation that was being pinpointed over here was that somebody has to make some certain feature in this particular matter, which is the legal literacy part I'm just talking about. A principle was laid down by the courts in itself, which now has become the matter of law in technical sense, that whenever such distribution is to be made, the eldest person should bifurcate into 4 parts or 6 parts or 10 parts as the case may be, and the youngest will pick up the items one by one in itself. So in that particular case, the judicial distribution will be made by the elder, and since all are equal in itself, nobody will be having any preference in it, the younger one will pick it up so far as the technicalities are concerned. This is how the law is required to be evolved, and the law is required to be developed and to be understood by us, and in that particular matter, the situation is required to be jotted down. In one case, I distinctly remember, because this was a case that has happened in my office also. There was a couple known as Kishore Pandit. Kishore Pandit and Yamini Pandit. These were the 2 people got married with each other. They were studying together in itself. And in the initial phase of their life, the father of the boy was comparatively not a much rich person, and the father of the wife was a school teacher and was just retired in itself, was getting gratuity, etc., etc. Now, when these 2 persons got married with the consent of both the parents in itself, they wanted to buy a house, and the house was being bought by the persons in itself, by the Kishore, that is the boy in itself. The question came for consideration that when the house is purchased by Kishore in itself, the father of the wife in itself said, no, 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 this cannot happen. I will not finance for entire matters in itself. I will give you if the property is only in the exclusive name of my daughter in itself. So accordingly, instead of buying a house in Kishore's name, the property was bought in the name of the wife in itself, Yamini. And the entire finance was being made by the father of the girl in itself. And accordingly, the matter continued over there in itself. After some time, what had happened was, both these persons were coming on a scooter near University Gate. A car or a truck collided with them in itself, and both of them died on the spot. Now the question came for consideration in that particular case was, both of them are not no more. So in that case, property stands in the name of girl. So it must go back to the father of that girl in itself. But the father of the boy said, no, no, how it can be? It is the ultimate property of the male in itself that should come in the name of my family, because I had also given sizable money later on. Initially he had given, later on I have given. So as a result of which, it was only 40% that was being paid by the father of the wife in itself, whereas 60% was being paid by the father of husband in itself. So the question came for consideration, what should happen in that particular case? So accordingly, this case was referred to the Legal Aid Center, where I was the moderator over there itself. Then I inquired what happened, how it happened. And I said that let us have amicable 40-60 should be the answer in itself. And accordingly, you settle the matter because amicable way is the best way to do that. But both of them did not agree. Both of them were bent upon that the entire property is needed by them. No other person cannot have it. Then we started working on that. Our boys are excellent in that particular legal matters. So they found out that how the marriage was being solemnized. So accordingly, it was found that it was their love marriage. Both of them were studying in the same class for 4, 5, 6, 7 years of time. So we just found out that what is the ultimate date of birth, and we noticed there that the girl was bigger than the boy in itself by 6 days. She was elder by 6 days to the boy in itself was concerned. So later on, we said that eldest person is being there, and this was the point of remark that ultimately helped us in overcoming this particular dispute. Then further negotiations were being made, and ultimately been pointed out that once the elder person dies, the property comes to the junior person. But they were not listening to that also. Then finally, the Supreme Court decision was being shown to them in itself, and which was nothing mere but the doctrine of simultaneous death. Doctrine of simultaneous death. What is this doctrine of simultaneous death? When two persons die at the same time, time is not known, or at the same time, as the case may be, law will presume that the senior person had died first and then the junior has died. So in that particular context now, since the amount was not being specified and whatever was the time that was not being specified, since the girl was 6 days older than the boy in itself, under doctrine of simultaneous death, she was presumed to be dead first. Then the property came to her husband for a fraction of second, and then the husband died. As a result of which, the husband's legal heir got the entire property under this doctrine of simultaneous death. So having a literacy about that, only that daughter is having a entire property financed by her father in itself, that doesn't suffice. You need to have something more bigger than that. And once you have that, then and then only you can find out a solution for the problem in itself. Once that is being done, nothing is difficult so far as the generality of the topic is being concerned. And that is what the major issue that what we need to make it out so far as the technicalities are being concerned. So in the light of that now, you try to concentrate on some important features which are just making out about the literacy part is being concerned. And this literacy part, you need to gather it up with the help of sizable matters which you need to understand and which you need to keep it up in mind. Once you do that, nothing is difficult so far as the technicalities are concerned. Now the questions will come. How you can improve the matter so far as the topic is being concerned, how the legal literacy can be improved. Now, the first way is by way of conversation. You need to have a friend who is having greater knowledge than that of yours. Otherwise, if the person doesn't have good knowledge than what you are having, then in that case, it is not going to be of any help. So conversation is very, very important. And once you do that, then only the things will happen in that particular case. I can give one illustration for that. So there were two people. One was the butcher and one was the Brahmin man who used to enchant some mantras every day. Two parrots were being carried out by one by Brahmin and the other by the butcher in itself. And the Brahmin man always used to enchant mantras, Gayatri mantra, spirituality, something of that sort. And as a result of which, the way in which he was enchanting mantras, the parrot also started talking in the same sense and in the same tone in itself. But that was not the case of the other parrot, which was being there with the butcher. You cut down the thread, you cut down the neck, you cut down the beak in itself, you cut down the leg in itself, throw it away, throw a particular parrot away. These were the words which were being jotted down by the parrot, which was being ultimately caged in the cage of the butcher was being concerned. So this conversation is very important. Who teaches whom is very important, and that is the major factor that you need to make it out. So if you are teaching a boy having if you are teaching a boy English language in itself, then there are two possibilities. Either you can improve the language of the other boy, or the boy can destroy the English language that what you have. So who changes whom ultimately is decided by the conversation. So more impactful person normally impacts the other person in itself, and that is the reason why we see that in our nowadays in our houses also, the after the marriage in itself, either husband starts speaking like wife, or wife starts speaking like husband in itself. Their children also imitate either the father or the mother, as the case may be. This is what the impact is being there, which is required to be looked into through conversation is concerned. So if you can embed or imbibe certain important legal principles within you, then in that particular case, you will be in a better position to interpret certain matters so far as the topic is being concerned. So you can enhance your capability, you can enhance many situations so far as the technicalities are concerned. Reading material, because you can improve your knowledge with the help of reading material. So this reading material is available on many aspects that you can go to the Google search, you can select a topic and ask for any other information, and you can find out the answer for the question in itself. May not be a correct answer, but ultimately it will improve your answer in itself. So that is what the new ChatGPT 5 is being there. A ready-made answer is being there, as like the guide that what we normally see when we were in school days in itself. When I was in 10th standard, Navneet's guide was being there. We used to follow that particular thing for giving an answer. So ready-made answers were being there, as like instant food that we normally see. We don't have to wait. Everything is being well prepared. Only thing is that there is a need to grasp that aspect in itself. Once you grasp that, nothing is difficult so far as the technicalities are concerned. More important nowadays is YouTube videos. Now there are very people, or hundreds of people or thousands of people are there. They have lost the habit of reading the material in itself. They can read WhatsApp messages in itself, but they will not read the newspapers, or they will not read the very important material which they need to and ought to learn in itself. And that is the typical feature that I just wanted to bring to your notice. So if you are having some deficiency in the matter in itself, you can just open up YouTube and have a lecture on that in itself, and you will improve your knowledge over a period of time is being concerned. Then certain consultation can be made, or even the seminars also can be joined. And with the help of that, you can make it out certain important features which you are comparatively very important to understand and know the matter is being concerned. So that is how the features are required to be looked into so far as the technicalities are being concerned. So let us move to the some other case studies which I have just brought it for your information in itself, which will improve your overall working of the studies in itself. Now this is another case where Sunita was fighting for her right to education. Sunita was a 14-year-old girl from village of Bihar, was pulled out of school to help with household chores because their parents were not earning even for the bread and butter. So she was being withdrawn from the school in itself. During legal literacy camp organized by the local NGO, her mother learned about the right to education 2009, which guarantees free and compulsory education for children in the age of 6 and 14. So this is a compulsory free education that has been given, the fact which was not known to this particular lady in itself. Armed with this knowledge, Sunita's mother approached the local school and demanded her for daughter's admission. The school complied and Sunita returned to class. Her future now no longer held hostage by ignorance in itself. So this is what the importance of the legal literacy it is being there. Right to Education Act, the principles of that were not known to a common lady working in the fields in itself. Once she understood that, she could use it up, and ultimately her daughter got educated in this particular matter in itself. So this is the major feature that I just wanted to bring to your notice so far as the technicalities are concerned. One more case. A nurse was serving in a hospital. Her name was Asha. He was serving in a private hospital. She became pregnant and requested for maternity leave. She got recently married, so ultimately got pregnant and ultimately requested for maternity leave. Her employer said, no, you are recently joined. There is no leave which is available to your credit. We will not give that. And citing shortage of staff shortage, she resigned quietly and unaware that she was entitled to a paid leave in itself. Now, what is the legal twist? Legal literacy. Months later, she learned from a friend about the Maternity Benefit Act 1961, which mandates paid leave for women in establishment with 10 or more employees. So when the organization happens to be having 10 or more employees, it is the bounden duty of the hospital or any other institution to make paid leave to the women, and accordingly the amount is required to be paid. So that is what the situation was being there. What was the outcome? With legal aid, Asha filed a complaint and received compensation. Legal literacy could have saved her job and protected her rights from the start. But she was not aware of it, and that is the reason why this difficulty arose. Let us move to case number 4. The father lost his child to assumptions. A happily married couple was there. Dispute occurred in between them. And since the wife was dominating in itself or the husband in itself, she took a divorce at her whim in itself. After a divorce, Vikram's ex-wife moved to another city with their daughter. Vikram assumed he had no legal right to contact her and stayed away from the daughter for years together. Now the legal twist. At a legal awareness seminar, Vikram learned about the Guardians and Wards Act 1890, which allows non-custodial parents to seek visitation rights. Outcome? He filed a petition and was granted monthly visits. His daughter, now 12, reconnected with him once again. What is the legal literacy help? Legal literacy helped Vikram reclaim a relationship he thought it was lost. So that is the feature which we need to make it out so far as the things are concerned. Case study number 5. The widow who was cheated out of her land. After her husband's death, Kamla was told by her in-laws that she had no right to the family land because it was ancestral property in itself. She accepted it silently, believing it was a tradition. What was the legal twist? A legal literacy camp in her village taught her about Hindu Succession Amendment Act 2005, which gives equal inheritance rights to women as well. Outcome? Kamla filed a case and reclaimed her share. Legal literacy turned tradition-bound silence into empowered action. That is very important. Case study number 6. The student who fought cyberbullying. Background. Rohan was a college student, was harassed online by anonymous accounts. He felt helpless and isolated. Legal twist. A digital safety workshop introduced him to Information Technology Act 2000 and the process of reporting cybercrime. Outcome. With the help of campus legal aid, Rohan filed a complaint. The culprit was stressed and penalized. Legal literacy gave Rohan the confidence to stand up and seek for justice in itself. Case study number 7. Ravi challenges unpaid wages. Ravi was a construction worker in Pune, hadn't been paid for 2 months' salary, 2 months' wages. He assumed there was nothing he could do because nothing was in his writing, nothing was in his hand. But after attending a legal awareness session by the District Legal Services Authority, DLSA, he learned about Payment of Wages Act and how to file a complaint with the Labor Commissioner. With the help of paralegal volunteer, Ravi filed a formal grievance. Within weeks, his employer was ordered to pay the pending wages. Ravi now encourages his co-workers to learn about their rights too. This is what the change that has occurred so far as the case study is being concerned. Case study number 8. Meena stops land grab in her village. In a tribal village of Madhya Pradesh, Meena noticed outsiders trying to acquire land illegally. She had attended a session by National Law Institute University (NLIU) on Tribal Land Rights and the Forest Rights Act 2006. Meena mobilized her community, filed a complaint with the local revenue office, and halted the encroachment. Her legal literacy turned her into a local hero and a protector of ancestral land. So this is the change of personality that can happen with legal literacy. Case study: a schoolboy files an FIR. Now there is a difference in between the word FIR and a complaint. Now complaint is nothing more but whenever you feel that everything is going wrong, you make a lodge a complaint with the police. That is called as a complaint. Once the complaint is being investigated by the police and the police find that yes, something is wrong and that has been what has been pleaded upon is right, then they register that complaint, which is being known as FIR, First Information Report. A 16-year-old student in Karnataka was bullied and had his phone stolen. He didn't know what to do until his school hosted a legal literacy workshop via the Diksha portal. He learned how to file a complaint, leading to first information report by police, and approached the police with confidence. The FIR was registered, the phone was recovered, and the bullies faced disciplinary action. His classmates now see the law as something that protects them, not something to fear of. That is the sea change that has been made. Case study number 10. Empowering tribal leaders in Arunachal Pradesh. Arunachal Pradesh Legal Services Authority, APSLSA, trained traditional village leaders, Gaon Burads and Gaon Buris, on how to integrate customary laws with India's formal legal system. This helped tribal communities resolve their disputes fairly and legally while preserving their cultural practices. So this is how the tradition and the custom also pips it into the legal literacy is the barometer that what we need to make it out. Then case study number 11, school-based legal awareness via Diksha portal. The Department of School Education Literacy uploaded legal literacy content on the Diksha platform, a digital education portal. Students and teachers across India now can access modules on child rights, cyber safety, constitutional values, making legal awareness part of everyday learning. So this is again a little legal literacy you can develop. Case study number 12, women's rights in Sikkim. The Sikkim States Commission for Women conducted training sessions for self-help groups, SHGs, on laws like Protection of Women from Domestic Violence Act 2005, Sexual Harassment of Women at Workplace Act 2013, Anti-Human Trafficking laws, etc. These sessions help women recognizing abuse, seek help, and support others in their communities in itself. Case study number 13, media sensitization in Manipur. The Department of Psychiatry at JNIMS Manipur organized legal literacy workshop for journalists and students to raise awareness about child sexual abuse laws. This led to more responsible reporting and better protection for victims in itself. Case study number 14, legal literacy for panchayat leaders in Karnataka. Using SATCOM technology, the Abdul Nadir Saab State Institute of Rural Development trained panchayat leaders on legal procedures and citizens' rights. This helped local governance bodies handle disputes issues like land disputes, domestic violence, and welfare schemes more effectively. These examples show that legal literacy isn't just about knowing the law, it is about using it to uplift the communities, protect the vulnerable, and strengthen the democracy. Want to dive into how legal is being digitized and gambling for youth engagement? That will be the feature which we need to understand and answer. Case study number 15, the farmer and the land grab. Ramesh is a farmer in Maharashtra, inherited ancestral property, but never registered it is in his own name. One day, a local builder began construction on the plot, claiming ownership through forged papers. Ramesh was devastated and felt helpless until a legal literacy camp in his village taught him about the Land Title Registration and Right to Fair Compensation Act. He approached the district legal aid office, filed a case, and proved his rightful ownership. The court ordered the builder to vacate the land and pay the damages. Legal literacy turned a powerless farmer into a defender of his rights. That is the power of legal literacy. Case study number 16, the nurse who fought for sexual harassment. Priya, a nurse in a private hospital, faced repeated harassment from a senior doctor. She confided in colleagues, but no one knew what to do. During a workshop on workplace rights, she learned about sexual harassment of women at workplace Prevention Prohibition Redressal Act 2013. She filed a complaint with the hospital's Internal Complaints Committee ICC. The doctor was suspended and the Priya's dignity was restored. Legal literacy gave her the courage and the tools to act in itself. Case study number 17, the father who claimed custody. After a bitter divorce, Arvind lost contact with his daughter. His ex-wife moved cities and refused visitation. Arvind assumed he had no rights until a friend explained Guardians and Wards Act. This we have covered. Legal literacy helped a father to reconnect his daughter. The widow and her pension. The same situation we have covered. And coming to case study number 19, Jaina's fear of the FIR. Jaina, a 24-year-old postgraduate, was mugged up on her way home in Delhi. The attackers threatened her with a knife and stole her phone. Terrified, she lied in her family, saying she lost it. She didn't want to file a police complaint. She feared harassment and did not trust the system. Her hesitation stemmed from the past incident where her friend Shafia was teased and upon reporting it was shamed by the police. Jaina's story shows that even educated citizens avoid legal remedies due to fear and mistrust. Legal literacy isn't just about knowing your rights, it is about trusting the system enough to use them. So that is another feature you need to make it out. Then last point that what we need to cover up in this particular first session, case study number 20, Babita's fight against female foeticide. Babita married at 14 and rejected her by her father for being a girl, grew up in hardship. She later became an ASHA worker and joined the Vanishing Girls campaign in Rajasthan. During a legal literacy training, she learned about the PCPNDT Act, which prohibits sex-selective abortions. For the first time, the law was explained in simple terms. Babita pledged to protect unborn girls and educate her community about the criminality of female feticides. Legal literacy empowered her to become a voice for the voiceless. So that is the pretty important point which you need to make it out. Legal literacy camp in rural area. In Haryana, villagers were unaware of their rights to pensions, water access, and labor benefits. The SM Sehgal Foundation, in collaboration with law colleges and the District Legal Services Authority, organized legal literacy camps. Through door-to-door outreach, posters, and community radio, villagers learned how to file complaints and demand services. One elderly man finally received his old age pension after years of being ignored. Legal literacy turned passive citizens into active participants in the governance in itself. So that is how the major points which are required to be looked into so far as the technicalities are being concerned. So this is the first part of legal literacy. We'll continue with this now, but the topic will be drafting of wills are being concerned. Now let us look into in terms of the will drafting is concerned, succession planning is being concerned. Now you all aware that life is all about planning for the uncertain future. We don't know anything about our future, and that is the reason why it is uncertain. Nobody knows when we are going to die or how long we are going to live. And one of the most important, significant uncertainties of life is that the timing of death. So timing of death is the most important factor which we are unaware of. And that is the reason why we need to concentrate on certain important matter so far as the technicalities are concerned. Now you are aware there are certain products which are available, Jindagi ke saath bhi, Jindagi ke baad bhi, something of that sort. And those are useful so far as the literate conditions are concerned, literacy is being concerned, and you have to concentrate on these particular matters in that particular angle. Now, this is why the humans have property and asset, because everybody has got some interest over there in itself. And the most important part which we need to understand and look into there is that after your demise, how the property will be distributed and how it will be managed so far as the things are being concerned. Now, the most uncertainty of life is death, which I told you. No one can predict in their lifetime that when the person sitting in the chair either will be hanged out on a wall and ultimately either in the form of photo frame or with a garland too of a sandalwood flowers, and that sandalwood flowers around the photo frame in itself, because nobody knows about that, and normally everybody will not see that type of picture in their lifetime. So this is the uncertainty of life which one has to tackle very skillfully, and that is the reason why the will becomes very, very, very important. Now, in two important points, I will just brief it out what is the will all about. Now, will is nothing but a legally binding document. Now you will ask me a query, that document means there has to be some non-judicial papers, judicial paper, something up. No, it is not like that. The paper itself will be called as a legal document. Once you write down on a piece of paper in itself, that piece of paper will become a legally binding document in itself. And that will itself will speak about that how the assets are to be transferred, how the assets are to be distributed, and whatever you will say in that particular paper, that will be having the backing of Indian Succession Act 1925. So in a brief manner, legal literacy part which I am just making out, that when you think about how the property will be distributed, how the property will be managed, there is no need for you to specify to whom the property is required to be given or otherwise, because that paper itself will be having a backing of the law, that is Indian Succession Act, which is formulated, accepted, formed by the Indian legislature. So this is a valuable legal document that enables you to clearly express your wishes, ensuring they are carried out with precision and care. Now you are aware that there are two types of contract, express contract, implied contract. When they are jotted down on a piece of paper or by mere words in itself, it is called as express contract. So once you jot down something on a piece of paper, it is express contract. And implied contract is the one by conduct you presume that you accept that this is a contract that is binding on you. For example, a PMT bus is coming, it's a proposal coming from corporation. You just get inside, it is an acceptance that you enter the bus in itself. The conductor gives you a ticket, that's a consideration in itself. You are going for a lawful purpose, all points are being specified, nothing is being jotted down in writing, yet it's a valid contract. That contract is called an implied contract. But in case of will, the contract has to be expressed in itself so far as the technicalities are being concerned. So if you don't make a will, what will happen? That is another feature that many of you might be thinking about. That if you don't make a will, then the property will pass on to the legal heirs as if the succession will be called as intestate succession, dying intestate. So in short, if your wishes are to be respected, if you intend that the property should not go to undesired persons, by you are ensuring that your desire should come to light in itself, everybody should listen to you, then in that case, unintended consequences should not happen. Then in that particular case, you need to draft a will and you must specify there to whom the property needs to be distributed. And that is what the one way to look at it is the drafting of will, which is a estate planning, succession planning that you need to keep it in mind so far as the technicalities are concerned. In India, perhaps you might be knowing it or not, that I do not know, but every concern die after a certain period of time. Old concerns are, old offices, old firms are no more in existence in India. But that doesn't happen in China. In China, the firms are being continued for 100 years, 150 years, 120 years, and still they are going on. Same old name continues even as of today. Maybe the stakeholders might change, but the succession pattern, the way in which the business was being carried out, the way in which the profession was being carried out, it continues to remain the same. And the same person, so that you can have the ability to find out the reputation of the concern is being concerned. Because to set up a reputation, you need 30, 40, 50 years of time. And those 50 years of time in China are being preserved, or you may say saved in the technical sense. And that is the reason why this is a major feature which we need to adopt in our law also, that the continuity in estate planning, succession has to be given more importance with the present ability to do the work in itself. Another feature that you can think about is the formation of a trust. Now, trust is of two kinds. One is called as public trust, and the second is called as a private trust. So I'm talking about private trust. I will just explain you the difference in between these two in a minute, and then we'll proceed further. Whenever in a particular trust, there are three categories of personalities which are involved. First is the person who drafts the will and who drafts the deed in itself is called as a settlor, or is called as trust owner. Now the person for whose benefit the trust is being formulated are called as beneficiaries. And the management through which this trust will be organized are called as trustees. The terms and conditions on which these functionaries are to function is called as a deed, and the content, the terms and conditions in which the document is being called as a trust deed. For example, Mr. Old, 75 years of age, is not keeping good health, having good property to his credit, worth rupees 100 crore. He has formed a trust saying that the property will be managed by ABCDE, his good friends. These are called as trustees. They will be managing the property. Mr. Old is the owner of the money in itself. He will be called as trust owner or settlor. Settlor is there, trustees are there. Now, for whose benefit this is being managed? He says that for the entire country, our country should grow up. Our economy should become number one in the world in itself. For that, the ultimate money should be spent. So it is for world at large. So in that particular case, the points, the world at large will be the beneficiaries in itself, and the terms and conditions on which this 100 crore or 1,000 crore rupees are to be distributed, these terms and conditions on a document those will be prepared will be called as trust deed. So when the beneficiaries in a trust are world at large, then in that case, the trust will be called as a public trust. I repeat, when the beneficiaries in the trust are unlimited or world at large, then in that case, it will be called as a public trust. But when the beneficiaries are identified, when the beneficiaries are identified, then in that particular case, the trust will be called as a family trust. For example, grandfather has 10 crore rupees with him, and he knows that his vagabond son number one, vagabond son number two, vagabond daughter number three are totally spending their money. So if the money is handed over to them, they will spend money, and after 2 years of time, they will become bankrupt and or a beggar in itself. So he has got one friend which is known as caretaker. Mr. Caretaker is friend of Mr. Old in itself, and that is the reason why he said that, Mr. Caretaker, I'm handing over this money to you. You every year, every month, give certain sum of money to them, and accordingly, 500 rupees is being paid or 5,000 rupees is being paid to each beneficiary in itself. Now here, the beneficiaries are only three, and that is vagabond son number one, vagabond son number two, and vagabond daughter number three. So accordingly, these three beneficiaries are there. Beneficiaries are identified. It becomes a family trust or a private trust. Now, private trust again can be of two categories in itself. One will be family trust, other than family trust. So if the person says that the entire beneficiaries in the local city of Pune, 45 lakhs, whatever people are there, those are identified by him, it becomes a private trust. It doesn't become family trust. When the family members are only incorporated, it becomes a family trust. Otherwise, it's a private trust in the technical sense. Now, succession planning can be done by family trust, and that is the area where just I'm going to highlight upon so far as the technicalities and the legal literacy part, which we need to incorporate or need to inculcate so that the estate planning would be useful, worthwhile in the times to come. Now, family trust is being jotted down on a non-judicial stamp paper if there need be, or it can be on a normal paper in itself. You can pay stamp duty later, and the document can be prepared as like the one that what I just mentioned. Trust owner has to be there, beneficiaries has to be there, then other thing can be there, and even the family trust can run the businesses also. It can run a ginning finishing factory, it can run a any other small factory, Yung pipe factory, or RCC cement pipe factory, any factory that can run. So family trust, only the thing is that it should be there and ultimately it needs to pass on. Now, what is the ultimate benefit of it? The ultimate benefit of it is family trust is being considered as an independent entity separately from that of the beneficiaries trust and trustees are concerned. So it is having a legal recognition to the existence of that particular family trust. And as like what we see in normal you and me, human being, individual, family trust will be another legal personality in the eyes of law, income tax law. It will have some different, again, the same structure as like partnership or AOPs or limited company would be having, and will be treated differently from that of the persons are concerned. Now, why family trust is necessary? Because I don't know whether this particular bill will come in front of the parliament or not, but it is there in United States of America, which is called as an inheritance tax. The moment at which you die, normally you have to pay the amount to the uh, government exchequer in itself in USA, not in India. It was there in India in the form of estate duty, but it was very nominal. Compared to that, now in USA, but I have been told that the inheritance tax is quite sizable. And if that is the case, then the question will come how you can move in the matter. And in order to overcome that particular aspect, for example, now I am having a property worth rupees 100 crore and inheritance tax comes to me in itself. And if the inheritance tax is 30%, out of 100 crore, 30 crore rupees will go to directly to government exchequer in itself after my death. So what I can do for that? Then in that case, I have to form a family trust in itself, because family trust can live for long. It has got an amruta with them in itself. It will never die unless the suicide is being there. Otherwise, nothing will happen to the trust. And I will hand over this property to the trust, and trust will carry on that particular property to the next generation for the use of that particular family in itself. So in that case, future action can be stalled with the help of this family trust in itself. And especially those who are senior citizens, they can always think about this particular matter in the times to come in itself. Family trust will be a very, very important point which we need to make it out and need to understand. There is another feature and a point which we need to make it about family trustee, that there are certain handicapped persons in the family, and the persons who are having good health, etc., are not cooperating with the family, that is the father and the mother in itself, to educate the handicapped person, or you may call it as a physically handicapped, mentally handicapped person in itself, causing some problems with them in itself. So in the light of that now, what can be done? Because the father, mother, they are having a limited life, because you know that the things which are required to be done are more. The life is, the time is very short. So in that particular case, how the short time will be helpful to them so far as the technicalities are concerned. And in the light of that now, the family can be ultimately taking care of the physically, mentally handicapped person with the help of a family trust, which can be run by the trustees in whom the trust owner would be having faith in itself, so that they can take care of their beloved ones after their death is being concerned. So that is the family trust which we need to take into account. The tax structure is very good, so no, not to worry about that in itself. And we can move into the matter so far as the technicalities are concerned. Let us move further now, because we need to take it into account certain illiteracy part which we need to make it out. In India, you might be knowing, every day 150,000 people are dying due to old age. Every day, I'm talking about every day, which is nearly 1/5 are dying in India. Of the world, 1/5 are dying in India. It means that in India, around 100 lakh people are dying every year. The first sentence was pertaining to the day, and the second sentence, which I'm just making out, is pertaining to the year. So deaths due to hunger are 25 lakhs. Nearly 462 people die in road accident in India, which is a world record. That is the major feature which we need to look into. Then from 2014 to 2021, around 98 lakh people have died because of insufficient medical care and COVID-19 victims. Every day, 28 farmers are dying, committing suicide, where numbers is more in Maharashtra. Thus, when one will die is not known, and hence the order to ensure handing over of the property to the desired beneficiary will is required. That is what the best feature that you need to make it out. Why will is required to be prepared. Second important point is that there is about 70,000 crore. It is written in this slide 50,000 crore, but the amount now that has enhanced. And now there are about 70,000 crores of property is being taken over by the central government for the management in itself, because the trust, the owners of the property were not in a position to draft a will, and they don't know to whom the property is required to be transferred in itself. And this is a huge wastage of efforts of those particular departed souls in itself, that they were having a property. If they would have jotted down a will in itself, the property would have changed the hands in itself. But since this is not being done, around 70,000 crore worth of property is still lying with the central government, being undistributed to the legal heirs are concerned. Now, the financial literacy in this part. In India, as per the report, only 9 to 10% of the people only draft and write their wills. In India, of the total person, 100 lakh people now, which we are talking about every day they die, the senior citizen I'm talking about, then in that case, only out of that 100 lakh, only 9 lakh people are only preparing wills, 91 lakhs are not being preparing. The same percentage in case of Western countries like USA and other is 46 to 60%, which means that nearly 60% of the crowd in Western countries are preparing their wills. This is illiteracy on the part of Indian people in itself. Many wills lack one or more elements such as not following procedural requirements, not updating the will in a timely manner. Many individuals are still associated with the idea that writing a will to death, unless you do, chances are there that you are likely to die, will is not being prepared. Some normally think that will writing is only the rich people is expected to do, but that is not the situation, the thing that what you need to consider. But most ignore that will enables the asset owners to transfer assets to the person they choose after the death of the concerned person. So this is the major issue which we need to make it out, which is the major misconception arising from legal and financial literacy are the major reason for not drafting and preparing the will in itself. Then the unforeseen may happen. Not having a valid will leave the family of the deceased vulnerable to unwanted legal exposure and in the form of conflicts in division of assets between the family members or their near and dear ones. There is a high risk of poking of the assets of the deceased by distant relatives or creditors not friendly with the family in itself. It may so happen that total assets of the deceased are not known to the family member as well. There is a risk of identity theft in case of social media essence, where the presence of the deceased in no case has been appointed for the management of the same. Then the multiple legal heirs may create problems. When multiple legal heirs are there involved in the matter, no will situation can lead to many complications and doubts. I will give you one illustration. A lady died without making a will, but keeping her sizable gold and diamond ornaments behind her. Gold and sizable or a diamond ornament behind her. She had two daughters-in-laws. The deceased had all types of ornaments, but all of them were in singular number. She had an excellent, costly diamond necklace too. In absence of will, both the daughters-in-law staked and lodged their claim on it. And finally, the matter reached to the court for justice. Finally, court ordered sale of it and proceeds were allowed to be shared by both the daughter-in-laws. The legal battle lasted for about 9 years, and in these 9 years, the family lost touch of love and affection, which otherwise could have been avoided had a valid will been drafted by the deceased lady in itself. So, keeping a family together can be ensured by drafting a will is being concerned. Now, consequences of intestate succession are to be avoided. That if you die intestate, then Hindu Succession Act will apply, and accordingly the succession will take place. First, it will go to the class 1 heir, then to the class 2 heir, then to the agnates, and then to the cognates. I will not name the who are the legal heirs because that's a very big topic to be discussed into so far as the Hindu male and female is being concerned. So we will not go into much details of that so far as the matter is being concerned. Straight away, we'll go to the uh, ingredients of the will in itself. That is more important for all of us. That will help you in getting the matter sorted out in itself. This is very important. These are the ingredients of a will, which are the important points. First is declaration, that is called as legal document, is in the form of legal declaration. It has been made in conformity with the provisions of Section 63 of the Indian Succession Act to ensure its proper execution and attestation as laid down. It has been made by a person competent to make it. Who is competent? Normally the person which we will see at a later point of time if time permits. The declaration should relate to the property of the testator and so on. Then the second important point which we need to learn into would be that once you prepare a will, there has to be a specific word that this will take its effect, or the will is required to be brought down into effect soon after the death or after his death. If these words are missing in the will, then it is not a will in the technical sense. So keep this particular point in mind so far as the technicalities are being concerned. A will written on a simple piece of paper also derives legal value being a will. So it is not necessary that the will has to be jotted down on a non-judicial stamp paper or something of that sort. It should be printed or otherwise. You can just jot it down on a with the help of pen and complete the page. That page will be called as a legal document. Now this will that is being prepared can be withdrawn, and that is very important point because it needs to be withdrawn prior to the death of the concerned owner in itself. Later on, it cannot be revoked in itself. That is peculiar feature which you need to understand. Then revocation of law is also there. Then exceptions are there. Revocation by act of parties is also there. There are certain important issues are being there. Now, the fourth important ingredient which we need to understand is stamp duty and registration fee. There is no stamp duty payable on documents of will and codicil. Codicil is the modification of will. Hence, wills and codicils do not be written on non-judicial stamp paper. There is a misconception that all legal documents, in order to have legal binding effect, should be written on non-judicial stamp paper of adequate value. However, even if the wills are or codicils are written on plain or simple or piece of paper, still these are being considered as valid legal documents. The registration fee of the wills and codicil are different across India as it is a state subject. In the state of Maharashtra, registration fee is only rupees 100. Every will must two witnesses. A will is a legal document that outlines the distribution of a person's property assets after their death. The process of creating will is governed by the Indian Succession Act. So the will is got minimum one important aspect of creating a will is the role of witnesses is being concerned. Now what the witnesses are expected to do? The witnesses have to observe that the author of that particular will is signing the will and attest its validity. In India, two witnesses are required for will to be considered as legally valid will. These witnesses must be present at the time of signing and should not be the beneficiaries of the will. Very, very, very important point. They should not be the beneficiaries of the will. The role of witness is crucial in ensuring the validity of will. They are responsible for verifying the identity of the person creating a will, confirming that the person is of sound mind, understand the contents of the will in itself. They also ensure that will is signed voluntarily and without any coercion. Additionally, witnesses play a very vital role in case of any legal disputes that may arise after the death of that person. If the validity of the will is challenged, witnesses can be called upon to testify and provide evidence about the signing of the will. It is important to note that witness must be competent to testify in court. This means that they must be of legal age and must not have declared mentally unsound, disqualified person from giving evidence in the court. In India, it is recommended to have witnesses who are not related to the person creating a will. This is to avoid any conflict of interest that may arise due to relationship with the person. Witnesses should be individuals who are likely to outlive the person creating the will, so that they can be available to testify if necessary. In short, the will must be attested by at least two persons. Now, there is always a general feature that each witness must have seen the testator sign. That is the major important point. He may sign or may affix his left hand thumb impression. Each must have received the testator's personal acknowledgement of his signature. Each witness must sign the will in the presence of the testator. Beneficiary In short, the will must be attested by two persons. And beneficiary, that is legatee or its spouse, shall never be a witness to the one more point that I just wanted to bring to your notice, that ordinarily wills are signed by testator himself. However, testator may, instead of signing the will, put his mark. Now here, whether the contents of the bill are required to be read by the witnesses or not, there is no compulsion on that. That is the major thing that you need to understand. Because every time they say that when I'm signing the will in itself, I need to know the content. That is not the issue. They may not read, or the testator may not allow them to read in itself. Then why will needs to be witnessed? That is another issue, because they can give the documentary evidence about that. Who can witness the will? That is also been jotted down. That is, a chartered accountant can witness, friend can witness, neighbors can witness, co-workers, a lawyer, any else testator trust can be. Then who shouldn't witness will? Those are being specified. Those who are beneficiaries, they should not do that. Then attestation is another important feature. A mere signing on will by another person does not always amount to attestation. Attesting means signing a document for the purpose of testifying to the signature of the person executing the document. It is not necessary that the witness should know the contents of the will. That is attestation, where I'm just making out. Executor of the will. An executor is someone who is named in a will to manage the deceased person's estate. The executor is responsible for carrying out the deceased wishes and instruction, including paying off any debts, making funeral arrangements, and other matters are being concerned. He has to execute the will and hand over the property to them. Now, only one controversy just before I conclude, because already I'm late by 5 minutes now, only that I wanted to bring to your notice, that if a person has been nominated by the concerned person as a nominee and some different name has been given in the will, for example, a fixed deposit of 1 lakh rupees is there and the nominee is Mr. A, but in will, they have specified that Mr. B will be the beneficiary of that particular property worth rupees 1 lakh. Who shall prevail will be the dispute. And the answer to this particular question is, will is a legal document, whereas the nominee is under regulations, as a result of which law matter will prevail. So anything that has been jotted down in the will be the major issue that you will have to look into, and that will be the case which we have to look into so far as the finality is being concerned. The beneficiary that enlisted in the will in itself will prevail in all the cases. So thank you for your patient hearing in itself. I am grateful to the committee in itself for allowing me to share some of the thoughts in itself, and accordingly, Aman has also briefed out the entire matter, the committee, what has been doing. I am proud of the committee in itself and the way in which they are getting the chartered accountants also engaged in this aspect, having similar knowledge in itself other than the chartered accountants knowledge. And maybe I am the only first beneficiary out of that. And that is the reason why I thank Mayank also, Hina Gupta ma'am also, for giving me an opportunity to share some of my thoughts. The topic is very big. I got at least 100 or 200 case studies in itself on this particular topic in itself.
That's great,
Very
sir.
difficult to enlighten and incorporate all these matters, especially when time is only 2 hours of time. So it's a big session for 6 hours in itself to cover up the entire matter in itself. And that too will be, whether it will be complete or not, that I do not know, because law is so complex, law is so much interesting in itself that you always find that it is very difficult to analyze what the other person might be talking about and what the other person might be thinking about. So thanks all for your patient hearing. Thank you. Thank you, Aman.
Thank you, sir. There is one question for you. May I proceed?
Yes, come to that.
So, Section 67 of Indian Succession Act 1925 generally states that any gift or bequest in a will to an attesting witness or a spouse or their spouse is void. The intention behind this rule is to prevent any potential coercion or undue influence by witness who stands to gain from the will. However, this qualification does not apply to wills made by Hindus, Buddhists, Sikhs, or Jains. This means that if Hindu is a witness to a will made by a Hindu and also named as a beneficiary in that will, then that gift to them remains valid. In summary, not only can a Hindu be a witness to a will, but they can also have a unique advantage of not being disqualified from inheriting under that will if they are also a beneficiary. This is the question.
I'll answer all together.
Pardon, sir?
I will answer all the questions together.
Okay. Just there is one question only. Any other question you can post, all the viewers?
So this is about Section 67 of the Indian Succession Act. That's what you are making out. And Section 67, even if it is what has been saying, in a brief manner, just I can tell you about that under Hindu Succession Act or under the Indian Succession Act, because Hindu Succession Act is quite a bit different. It has got a different modus operandi so far as how the property will devolve upon the other. But when you are jotting down through a will in itself, then Indian Succession Act will apply. So in that particular case, for others it is Indian Succession Act, and for Hindus it is the ultimately Hindu Succession Act from 1955 onwards. So this is the main difference that we will have to look into. So if a person is Hindu, we are talking about, and if there is no tested succession and that the succession is intested, in that case we need not talk about any other succession. Straight away it will go to Hindu Succession Act, where the class 1 heir, class 2 heir, agnates and cognates, and finally to the government under escheat will go to property in itself. There are 12 legal heirs in class 1, then class 2 heirs are also there. Agnates are n number, cognates are n number, and if none of them is there, central government will take over the property. So there cannot be a property which will remain ownerless even for a fraction of second. So somebody will be there who will be the owner of the property. Either the class 1 heir, class 2 heir, class 3 agnates, cognates, or government. Nobody is there, government is the owner.
I hope this is convincing answer. So, any other questions? Please post them.
Let us conclude.
Sure. So, thank you, sir, for sharing deep analysis and deep insights, along with the case studies and practical guidance on will drafting and estate planning. Even being a law student, I learned a lot from you today through this webinar. And on behalf of ICI Committee on Corporate Commercial Laws, Corporate Advisory and Economic Advisory, and NPO Cooperative of ICI, I extend our heartfelt gratitude to you and all the participants. We have around 124 participants who joined this webinar today. I hope uh, you added value to everyone. In my life, you added literally value, being a law student, as I told, and you really enhanced my professional knowledge and so that I can guide my clients and society as a large as well. Now, after your webinar, thank you, sir.
Thank you, Aman. Thanks a lot.
Pardon?